Hi, I'm Caitlin Jenkins, the Family Law Vlogger. This vlog is one of a series of vlogs arising out of the COVID-19 situation, and the one today is particularly looking at the situation of court hearings and whether they're going ahead or what the courts are doing in relation to those hearings during this lockdown period. So this vlog is being recorded on the 10th of April, and as the situation is changing quite a lot and very regularly, you really need to check and update the situation because this vlog can only really be accurate as at today. The other thing to say is that different courts are doing this differently, so there's a lot of difference across the geographical areas. At Mills and Reeve we have offices in 6 different cities across the country, and so we do have a good feel for what's going on nationally. But of course that doesn't necessarily mean that that is your particular local court or that the local practice is being adopted as the same as the general practice across the country. So I suppose whilst this is general advice or general information, you really need to check the situation with your local court, using your solicitor if you have a solicitor, or otherwise checking the websites, etc., and looking out for communications from your local court about what exactly is happening to your hearing locally. Having said all that, what's the general picture? Well, the first thing to say is that some of the courts are actually closed, and if you go on the website, which is www.gov.uk, there is a particular page which is called the Courts and Tribunals Tracker for coronavirus, and if you go onto that website, it'll tell you whether the court that you have a hearing in is actually even open. So that's the first thing to check. The second thing is, if you've instructed a solicitor, is obviously to talk to your solicitor, or if you've got a direct access barrister, talk to the barrister or their clerks about what the status of your particular hearing is that's already been listed. Even the courts that are open are offering what's known as a scaled down service. So that's partly because they also have staff who aren't able to operate due to illness, and also because the courts are trying to operate remotely. And what they're finding is that telephone hearings or Skype hearings tend to take longer than hearings in person. So even if you find that your hearing is going ahead, it may well be that it's going ahead not in person but by video call or by telephone, so you need to check the specifics of that and what you need to do to take part in that hearing. And it also may be that the time of that hearing has changed, so it might, for example, have been listed for 11 a.m, but the local courts we're finding are listing fewer hearings, even for the hearings that are going ahead, because the judges and the magistrates are finding that those hearings take longer, dealing with them remotely. So check not only that the hearing is going ahead, but also what time it's going ahead and how it's happening. So is it telephone? Will you be phoned? Do you need to dial in? Is it Skype? Same sort of questions. The court service has announced a telephone line for technical support for telephone and video hearings. Now, I should stress that this is for technical support, not for advice about whether hearings are going ahead, etc. But that technical support phone line is 0330 808 9405. So that's a useful number if you know that your hearing's going ahead, but you're not quite sure how to deal with the technical side of it. The other point just to mention is the court's general approach to whether hearings should go ahead at all. So what we're finding is that the courts are having to prioritise. They don't have enough staff and they're not in a situation to be able to do all of the hearings that they've been doing throughout the country in relation to all the different family law issues that land in court. And I'm talking here about family law issues. So the courts are prioritising, and in very, very general terms, what they're prioritising is public law matters. So, for example, emergency protection orders, interim care orders, those sorts of things are being prioritised and are much more likely to happen, those hearings. Then they're prioritising other urgent private law children issues. So, but only really if they're genuinely urgent and if that's the court's evaluation of what is urgent. So that's things like threatened child abductions or child safeguarding issues. Those sorts of hearings we're finding are often trying to be listed or going ahead. So the hearings that are less likely to go ahead are the hearings that are not as urgent. So private law children hearings that aren't as urgent are often being taken out of the diary, or if their final hearings are being relisted as directions hearings or other form of dispute resolution hearings. And on financial hearings, financial remedy procedures, again, even final hearings that have been listed to sort everything out for the long term, we're finding are not being prioritised by the court service unless there are truly urgent aspects to it. And what they're doing instead is listing a directions hearing to set further timetabling or case management directions. So that is, as I say, a very headline version of the prioritisation that's going on in the court service, and different courts in different areas are interpreting that differently depending on their their local staffing levels, what their judges are able to do. But broadly, if the evaluation is that your court hearing isn't within the truly urgent category, and I suppose the other urgent category I should have mentioned is domestic violence and protection of that nature, then it may well be that your hearing doesn't go ahead, or it doesn't go ahead, but it does go ahead, but it's listed differently for a shorter period of time, isn't the nature of the hearing that you were expecting or it was originally listed for. A further practical point relates to the papers that the courts tend to have. Now, obviously the court offices aren't open in the way that they normally are, so any court bundles, the paperwork that the judge or the magistrates need to see for hearings that are going ahead, have to be delivered electronically, usually by PDF. Now, the technical support line may be able to help you with what that looks like, and obviously if you've instructed a solicitor, then your solicitor or direct access barrister will be able to help you with that, but that is another change in the way that the courts are having to operate during this period of time. The final thing I would say about this situation is that it is fast moving and changing, so you do need to keep an eye on the situation and keep checking whether your hearing is going ahead, because the situation in a week or a couple of weeks' time could be very different to that which I've described today on the 10th of April. And the final point I would say is, in these days, more than anything, with hearings being adjourned, we as lawyers are being asked to focus increasingly on trying to resolve disputes without resort to the court. So I and my colleagues are urging every client or everybody who's got a family law dispute to think about whether there are other ways of trying to sort the issue out. And there are separate vlogs about some of those different ways, so from mediation to arbitration to the collaborative law process. So it would be worth having a look at those and to see whether the family law issue that you've got listed in a court hearing for it could actually be solved in a different way. As always with the family law vlog, and particularly this one, this is only really general advice. The situation is fast changing and is different geographically. So if you have any particular questions, you should take advice from a family law solicitor. And my details and those of the Mills and Reeve family team, who are operating as normal, albeit remotely, are at the end of this vlog.